This is outside of the Supreme Court right now, where, of course, protesters gathered last night following a leaked initial draft majority opinion written by Justice Samuel Alito back in February. The draft opinion circulated inside the High Court and obtained by Politico says justices voted to strike down the landmark Roe v. Wade decision, which has guaranteed federal abortion protection since 1973. Chief Justice John Roberts has now confirmed the authenticity of the draft. The draft states, quote, Roe was egregiously wrong from the start, and there is no constitutional right to abortion services. Justice Roberts has now ordered an investigation into the leak and says while the draft is real, it does not represent a decision by the court or the final position of justices on the case. As of now, there's no word on when the official opinion of the U.S. Supreme Court could be released here, which leads us into our next discussion. Who leaked this document and what potentially could they face? What is that investigation going to look like? I want to bring in legal analyst Doug Burns. Doug, you were with me when all of this broke just yesterday, and we've gotten new developments. You've had a chance to take a look at the opinion itself. But I really want to focus now on the leak. People are probably pointing fingers, and there's a lot of discussions, I would imagine, that are happening behind closed doors. Let's walk through this.
It's very interesting because you really do have the mixture of, law and then, of course, politics and media. So you have to kind of sort it out. I mean, basically, the theories that are going around, one notion is that, one of the liberal justices chambers, law clerk, disseminated this under the political idea that it would cause some kind of, backing off by one of the justices, to change the vote. Then you have the exact flip side. Oh no, the conservative side of the court disseminated it, and that was to prevent a justice from changing his or her mind. I happen to think that it's the former, but I don't have to, go overly into it. But the reality is, as we said last night when it first happened, there are two discussions, and all day long, I'm watching the two discussions just being mixed together. Okay, so one guest today, literally on a show, was asked point blank, I understand your position on abortion, your substantive position, but on the leak, what do you think? Don't you agree that this was terrible? Answer, literally, I kid you not, if this decision is allowed to stand, it's going to be terrible and horrible. Second time from the host. Well, wait a minute, sir, with all due respect, I just asked you, do you think the leak was bad? If this is allowed to stand, it's horrible. And I said to myself, this is almost like a psychiatric exercise going on here. I can't believe this. So the point is, I think it's very important for the viewers, for everybody to understand that they have two discussions. One is the substance and merits of Roe versus Wade and federal abortion authority. And then the other one, of course, is this horrific breach, absolutely stunning, breathtaking, full-on attack on the Supreme Court itself. Now, on the investigation, it's interesting because you have a bunch of different moving parts. The Supreme Court has its own police force, the Supreme Court Police, and I think there's something like 190 members. That's a lot. Then there's the Marshal of the Supreme Court, who I just learned fairly recently, today, is actually the titular head of the Supreme Court Police. Now, the Supreme Court Police are responsible primarily for the security of the building, the safety and security of the justices, safety and security of dignitaries who visit the building, very common lineup of functions that they do, but they also do apparently have arrest power and so on. So I think the point is, at least initially, it's going to be pretty much an internal Supreme Court investigation, okay? And to get a little more specific, they are going to get cell phone, email, and text information from all of the, I think it's 36 law clerks, okay? And they're going to start combing through all of that. And you'd be surprised, it's going to be pretty effective because they're going to be able to figure out, they know which media entity broke the story, right? So not for me to be a detective or Sherlock Holmes, but just follow me. So they get all of the contact information, for example, for that reporter who I saw on television openly. I forget his name, Gerstein, I believe it is. Get his contact information, get his records. What did he receive in terms of emails, texts, and so on. Same thing on the other end, all of the law clerks, and start piecing it together. So I'm sort of predicting that they're, we said this last night when it first happened. I'm confident that they're going to figure out who leaked this information.
That's an interesting conversation in itself, because as a journalist, sometimes people leak you information, give you information as an anonymous source. So
you could take this to any level you want. I mean, we've had journalists, as you well know, being a journalist yourself, jailed, imprisoned until they'll disclose a source. And many of them correctly, in my opinion, stood on the moral principle and legal principle, in a sense, that they are not going to give up their source. Okay. So, you may see something possibly along those lines. It's hard to say. I don't think it'll get that drastic, that dramatic, but the reality is you could certainly ask Mr. Gerstein in a grand jury context, grand jury subpoena, who gave you this information. I fully expect that he would decline to answer that, standing on source privilege. I get that. But back to my initial formulation, again, they're just going to start drilling into, communication, electronic communication, phone calls, emails, and texts of all 36 law clerks. Also, hang a footnote, I said last night, and I spoke to an expert today, it was interesting, who was over in Europe, but that's irrelevant. But he was a law clerk for Chief Justice Rehnquist, 30 years ago. He was also head of the Office of Legal Counsel, very prestigious figure. And he was saying that, I ran by him, I said, well, wait a minute, there's also some clerical people and printers who are privy to the information. I mean, think about it. Now we're talking law enforcement X's and O's more than, all of the political foaming at the mouth. So, you have a printer who was responsible for printing that opinion. They're going to want to have a chat with anybody who was involved in that. You have clerical and secretarial staff, but again, in the political dynamics and discussions, it's much less likely that it's that. But at the same time, there was a split of opinion. One expert I spoke to today said, he was a longtime federal prosecutor, a lot of experience, said, Doug, I'm certain that it's more likely to be clerical staff than a law clerk. The other expert said exactly the opposite. No, I do not think it's clerical staff. So I'll break the tie. I think it was a law clerk. But again, I don't have an infallible crystal ball. But I think it's much more likely that it was a law clerk than secretarial staff. And then you get into the related discussion, unfortunately, which is that, not only is the person that hasn't been identified yet not being condemned, right? It's almost, there were tweets and stuff, which isn't really so much my area, but, oh, this is a hero and this person's fantastic. That's troubling to me.
Yeah, there has been opinions that this person might come out themselves and say, I had to do this, I felt obligated to release this document to everyone ahead of the decision being made. I'm curious, though, with these people that what does it take in order to get into that clerk position, that law clerk position, let's say? Is there anything that you have to sign? What type of, what are the steps you have to take to make sure that you have transparency, but you're not releasing documents like this?
No, it's a great question. I told you last night. First of all, I'll answer your question, and then I'll bring back what I said last night about Chief Justice Rehnquist, the late Chief Justice. Basically, obviously, Supreme Court law clerk is an extremely, extremely elite position. It's considered the absolute gold standard for a young lawyer to get that position. And in fact, it stays with them their whole life. Oh, the associate working on this case is Joe Jones. That's a hypothetical name. Do you realize he clerked on the Supreme Court? I mean, it just goes, it's very prestigious. So these are very, very elite top students from generally, top law schools. Fine. But your question, which is very good, is no, they're going to sign, some confidentiality documents. Laura Ingraham last night said that Chief Justice Rehnquist gave everybody a welcome speech, for lack of a better description. And he said, if anybody breaches any confidence around here whatsoever, you will destroy your career and never practice law again, things like that. So the point is, but what you're getting at subliminally, it's interesting, is there may not be sort of formal legal requirements. And that starts getting interesting. And I'll tell you why in a second, because, the ethics are clear, obviously, not to disseminate any work product of the court, period, end of analysis. Okay. A lawyer who does that, huge, massive ethical breach, can and should be and will be disbarred from practicing law. The other discussion, which you may want to go into in a minute, is whether or not it's a crime. That's kind of a tricky question.
Yeah, we're definitely going to be diving into that. I want to stick with the investigation for right now, though, Doug. You mentioned that as of right now, this is internal. Justice Roberts saying today that an investigation has been opened already. We're not going to know the specifics of that. I'm sure of it. But do you foresee like the FBI getting involved?
Well, that was my next comment. So the point is, yes, right now, Supreme Court police, the justices themselves, trying to find out, possibly calling their law clerks in one at a time, each of the four for each justice, and say, look, we can do this, the easy way or the hard way, and why don't you just tell me what happened, type of thing. And then to your point, and you're right, then you start ratcheting it up a little bit, and you could definitely see the FBI brought in, the Justice Department. The FBI is part of the Justice Department. People sometimes don't realize that. So DOJ/FBI could definitely start investigating it. That takes it up to a more serious level because, ironically, Supreme Court law clerks, are being trained legally. So let's say, just in a hypothetical, they said, I want to get an attorney, or, I don't want to speak with you. Again, if the FBI is investigating, you can get into the level of, grand jury subpoenas and so forth. And then it really starts ratcheting it up. Because unless you assert a Fifth Amendment privilege, for example, saying that what you're going to say is going to incriminate you, you have to answer. So again, I honestly am quite confident that you're going to find out who did it. And I definitely heard you loud and clear, your point, which is I think the person might conceivably step forward.
Yeah, and we'll be watching that going into the rest of the week here. You stepped on it, and we're going to continue to talk about this through the rest of the evening here, but possible criminal charges against this person.
Yeah, that's interesting. I read an article, it's so interesting. And in the article, they were talking about what potential charges, and they quoted a law professor. So I emailed them, but I haven't heard back from him, so that's interesting. But yeah, but the point is, no knock on him. But in there, they cited a statute called Section 641 of Title 18, not to get in the weeds, as a potential charge, taking something of value. I don't see that would be the one that necessarily fits. I looked at a section for the home Googlers, 18 U.S.C. 1905-1905. 1905 of Title 18 talks about disseminating information as a government employee that's not authorized by law. It's a misdemeanor. It seems to have some potential applicability. My mind was jogged because I prosecuted kind of a silly case, for lack of a better term, where somebody at the IRS in Holtzville on Long Island photocopied the tax return of a very, very famous musician slash celebrity, showed it to her friends. And I think it was Section 1905 possibly in that case. So again, but one of the experts I spoke to said it's really not clear. And the article I mentioned, quoting that professor, was saying it's not 100% clear whether it's really a criminal violation. For one more minute into the weeds, if you look at 1905, it's interesting. It talks about, in the title of the statute, it says confidential, but that's really more of a term of art. In the text of the statute, which really controls, it says, disseminated in violation of law. So that's the open question is, while it's clearly, and this is a good way to put it, I think, clearly a massive ethics breach, clearly outrageous behavior for a Supreme Court law clerk. But the discussion of does it violate a federal criminal statute is very often a little bit more of a, serious discussion. And that particular statute is a misdemeanor, by the way, 0 to 1 year prison exposure.
Right. I mean, this is unprecedented territory that we're stepping into. There's
It
obviously been leaks in the past to the press in different capacities, tax returns, whatever. But
Right.
For a document of this stature, nothing.
No, I mean, yeah, this is really, again, by resort a little bit to the political discussions today, which sort of predominated in a good deal of what I was watching. Again, one side, the left launches just breathlessly into how outrageous this is. It's actually kind of funny, by the way, because some of the rhetoric they're using makes no sense. So they say 9 unelected justices are going to do this. Oh my God. Well, wait a minute. Excuse me. When the same 9 unelected justices did something that you loved back in 1973, that was wonderful and fantastic. So the point is, they really should just think through some of these arguments. Then they turn around and they say abortion, and this is important because you stressed this last night, and I think you're continuing to stress it. Abortion is being eradicated in the United States of America. That's completely false, okay? You've heard expert after expert calmly explain that this is a distinction between states' rights and the federal government, okay? And then the really troubling one today, troubling most notably because it came from very high levels, the President of the United States and Charles Schumer just breathlessly saying, okay, this calls into question other reproductive rights decisions, such as the same-sex marriage decision, Obergefell, such as the contraception decision out of Connecticut, Griswold versus Connecticut. I heard Andy McCarthy calmly point out that, well, wait a minute, they're not very familiar with the opinion today because Justice Alito took great pains to calmly explain that in his view, under the 14th Amendment, without getting in the weeds too much, there's a clear distinction between those cases involving, for example, birth control and other privacy rights and abortion. He drew a clear distinction between those two. So again, it's very troubling for those of us who, read the opinion or following a little more closely, because this is what we do, to hear these kind of political sound bites. Very, very troubling. And it's crystal clear, by the way, to delve into the area that's not my area per se, that, you've heard all the political experts say, they view this as a Hail Mary for November. I mean, that's obvious.
Yeah, I also want to note, while we're on it, President Biden released a statement. He said the Supreme Court should not overturn Roe versus Wade, but if it does, he'll work to protect abortion rights through legislation. He also called on voters to elect pro-choice Congress members to, quote, protect a woman's right to choose. So we're going to be hearing
but
from
that right there gave away the agenda. So I actually listened to that as he was speaking, and you have to vote for Democratic congressman. That's it's all about November angle to this.
Well, man, we could go for a really long time on this, Doug, but any last thoughts here as we move into some of the other top stories of the day?
No, my last thoughts are that, this is two discussions. One is the leak and the breach of confidentiality and how outrageous it is, and how in the toxic political climate that we find ourselves in, the left could care less, never even mention it. I even heard Senator Schumer was saying that the right is improperly focusing on the leak. They're desperate to talk about that. I mean, it's devolved to a really, really terrible level, the debate and the discussion. The debate should be a lot more straightforward. We understand that not everything's a federal right, and this is to be done in the states, but that's not the discussion you're getting, and it's really sad, and all I can hope is that maybe it'll turn around a little bit, but it's really toxic right now, really bad.
All right. Legal analyst Doug Burns live with us here on Live Now from Fox. We appreciate it. We'll talk to you soon.
Thanks. Appreciate it.